why don't you start?
So the respondent has to go first in jurisdiction.
Okay, yes.
Beginning, ma'am.
Yes,
May we begin?
yes, please.
Thank you. Greetings, Madam President, and respected members of this tribunal. My name is Niyal Pratap. My co-counsel Abhishek Mishra and I shall be representing the interests of the respondent, the Republic of Tyria, in the present matter before this tribunal. For a time period of 18 minutes, I shall be dealing with the request for provisional measures and the two matters relating to the jurisdiction of this tribunal to try the dispute. And for a time period of 20 minutes, my co-counsel shall be dealing with the two issues relating to the merits and damages of the case. If there are no preliminary questions, the counsel requests permission to proceed with the submissions.
Yes, please do.
Thank you. The first contention put forward by the counsel for the respondent is that this tribunal should grant the provisional measures sought by the respondent. For the granting of provisional measures under Article 47, read with Rule 39.1 of Chapter 5 of the Arbitration Rules, certain criteria need to be met. These criteria will be listed as follows, and the counsel shall implead them in the order as listed. The first being the existence of prima facie jurisdiction. The second, the existence of rights susceptible to protection under Article 47 of the Convention. Third, the existence of urgency and necessity to grant these rights. At the outset, the counsel would like to state that the counsel senses some concern.
No, nothing.
Thank you. At the outset, the counsel would like to state that since it is the state which is the respondent bringing forward the request for provisional measures, prima facie jurisdiction is already by nature vested within this tribunal under Article 47 as well as under Rule 39. And if for the respondents were to set up their own case for prima facie jurisdiction, would be setting up the negative against their own interests. Proceeding on the second contention, we implead that there exists certain right, specifically the right to non-aggravation, as requested by the respondent in paragraph 1 of the request for provisional measures, which the tribunal may find on page 36 on the record.
Do you require us to look at it, or will you be proceeding in your
We
argument?
should proceed. The right to non-aggravation is indeed a procedural right that we are requesting to be included under the ambit of Article 47, and as such preserve right of non-aggravation against the measures undertaken by the claimants through their hiring of a public relations firm, as well as them engaging in a large-scale media campaign in order to aggravate interests and cause prejudice towards the case put up by the respondents. Firstly, the tribunal in Kibarax v. Bolivia stated that the class of rights that may be protected under Article 47 include substantive as well as procedural rights, such as the procedural rights of the self-standing procedural rights of non-aggravation and to maintain the status quo. Further tribunals down the line, in quoting Christoph Schruer, have noted that the several class of disputes and requests for provisional measures are those requesting preservation of procedural rights, and has therefore become rather common for the procedural right of non-aggravation to be requested in these provisional measures. The counsel shall now attempt to implead before this tribunal the measure of aggravation that is being caused by the claimants against the respondent's interests. If the respected tribunal please take their attention towards the list of articles in paragraphs 3 and 4 on pages 37 and 38, 36 and 37 of the record, the highly confrontational nature of these articles, including titles such as Error 404, the freedom you requested cannot be found, clearly indicate and show the claimant's intention to aggravate and turn public opinion against the respondent, even after the fact that they have resorted through, if by noting the Global Herald article dated October 2018, have resorted to selectively submitting case material sensitive towards this dispute. No tribunal, including the Bywater versus Tanzania Tribunal, found that while public discussion is something allowed under ICSID arbitration, distortive use of selective case material in order to cause prejudice towards the interests of one party can at no point of time be engaged in. This was elucidated in greater detail as in the tribunal's award in Abaclat versus Argentina, wherein the tribunal did accept the fact that a general discussion of the case was in order for avoidance of public doubt. However, such general discussion cannot A. include the publication of selective case material in a distortive manner, and B. must not be used as an instrument to antagonize the parties, exacerbate their differences, or unduly pressure one of them, or more importantly, render the resolution of the dispute by the tribunal to become ever more difficult.
But isn't there a greater public interest in having these matters brought out openly? And isn't that part of the ICSID philosophy, rather than have it cloaked in some secrecy, confidentiality?
Thank you, respected arbitrator. To address that question directly, the counsel for the respondent does not condemn freedom of speech, nor do we condemn general discussion of the facts. However, we are claiming, by virtue of them hiring a public relations firm, as well as selectively releasing case material to the public, they are not engaging in critical and fair discourse. Rather, what they are doing is presenting their own distorted opinion in order to prejudice not just the public opinion, but may also cause vested interests within Tyria to turn against them.
And would you be agreeable then for all of the materials to be made public? If
Pardon?
you're saying the problem is selective material.
In regards to this, a similar question was posed before an earlier tribunal in Gramercy versus Peru, wherein they found that, yes, it is true that the tribunal cannot simply exercise control over all forms of communication. However, they may exercise control over communication provided it affects the integrity and efficiency of these proceedings. Respected arbitrator, we would not be in support of selectively releasing case material, for this would firstly prejudice interests against one party and would alienate the concept of general discussion. For if only one party presents their selective opinion, it would cease to be public discussion and would wander into the realm of a distortion of facts, which we condemn. If the arbitrator is satisfied, the counsel requests permission to move to his final sub-contention in this regard. Thank you. We would address that there indeed exists urgency and necessity in the granting of these provisional measures. The aspect of urgency and necessity was discussed by the ICJ in the passage to the Great Belt case, more formally known as Finland versus Denmark, wherein the tribunal found that urgency is justified wherein actions prejudicial towards the interests of one party are likely to continue if no measures are done to curb such actions. Specifically, in our regard, the claimants, especially through the promulgation of their articles, are fueling the flame of civil unrest in widespread areas of our country, as well as the fact that it is temporarily affecting our position as a transitioning economy. This political situation in Tyria is volatile, and the claimants' distorted version of their facts is simply to add fuel to the fire. Civil unrest has caused hundreds of deaths and is continuing to spread across, and the granting of these provisional measures is the only way to stem this tide of distorted material. For this is not fair public discourse, but is simply inciting action against Tyria, a state wherein we are simply trying to handle a volatile political situation. Urgency and necessity are established in the sense that actual harm in our case has already manifested in the form of civil unrest, and as such, some form of control by way of provisional measures may be granted by this tribunal under two criteria, which was defined by the Bywater Guff versus Tanzania Tribunal, wherein they stated, even though it need not be necessary for actual harm to have manifested before provisional measures are granted, the reasoning they employed is provisional measures are meant to be a preventive notion, not a curative one. Some form of control, if there exists a sufficient risk of harm, as is shown through our request for provisional measures, as well as in a statement of uncontested facts, stating that there has been large-scale violence as well as riots within our city causing hundreds of deaths, and the cause of aggravation is severe, respected arbitrators. This is likely to continue, as when I stated actions prejudicial towards our interests, if these provisional measures to stem the tide of articles being propagated by the claimants is not granted.
What do you contend is the applicable test that this tribunal should apply?
Two criteria, Mr. Arbitrator. Firstly, that there exists a sufficient and susceptible risk of harm. Now, that harm has already manifested in the sense of our civil unrest, as well as widespread violence, as well as aggravation against our interests. As in the state of the Abakla Tribunal, they had stated that such actions undertaken by the claimant should not result in antagonizing the parties. Through the very nature of these articles, as well as the names given under paragraph 3 of the provisional measures, their intention is made clear, that of antagonizing the parties. Therefore, this meets the criteria of both being susceptible risks, as well as rampant aggravation against our interests.
Mr. Counsel, are you agreeable to your pleadings also being made public?
We would not be agreeable towards any selective representation of material, Mr. Arbitrator.
That's why I'm asking if your pleadings are also made public, just as they are putting their side of the case in the public domain. Instead of restricting that, the other way to meet the selective dissemination of information which you complain of is for your pleadings also to be made public.
Respected arbitrator, that would be effective if it were not for one concept, popularity. If we turn to paragraph 2 of the request for provisional measures in the record, they are propagating this material through platforms including FriendsLook outside of the country. The fact that it's flagged as, and I quote, popular across FriendsLook would intend that their distorted message be made more public than anything we could do, which is for the simple reason that we're implementing provisional measures. If this tide is not stemmed at the roots, it would reach far more people and cause far more misinformation just simply due to their popularity than it would if we were to make our statements public. Proceeding to the
Do you require further provisional measures? After you block them off, do you require further provisional measures?
The provisional measures that we require in this is to stop them from engaging these public relations firms and from releasing articles such as this. Because, respectfully, Madam President, the blocking would not have no effect if they were to find a turnaround such as this. They would simply be selectively publishing case material, because if that were not to be the case, there is no way Global Herald would have been able to receive the request for arbitration. It would have come straight from them. If this request is not granted, they would simply continue to hire more firms, find more resources, more online publications, and continue to spread their message of distortion, even though their platforms were blocked for this very same reason. The next contention made by the counsel for the respondent is that this tribunal respectfully does not exercise jurisdiction over this issue, given that the respondents have formally denounced the convention as of 5th January 2018. For the sake of convenience, the counsel shall state the factual timeline of events. 5th January 2018 is the date of receipt of notice by the depository. This denunciation, according to Article 71 of the Convention, will become effective 6 months later, on 5th July 2018, and the claimants have submitted their request for arbitration on 29 June 2018 and was registered on 16 July 2018. Proceeding on these facts, we contend that we had not given consent to these arbitral proceedings prior to the date of receipt of notice, that is, prior to 5th January 2018. Respected arbitrators, for an obligation to be held against one of the parties, consent to such jurisdiction under Article 72 should have been perfected before the date of receipt of notice. Speaking in terms of an express and literal interpretation of Article 72, Schroer opined that in order to be preserved by Article 72, consent must have been perfected before the date of receipt of notice of denunciation, because the provisions under Article 71, which allow for denunciation of the Convention, do not afford an opportunity to perfect consent during the 6-month period. Now, in the case of Fabianca and Owens-Illinois versus Venezuela, the tribunal found that when provisions resorting to ICSID arbitration are set out in two separate international instruments, which in this case happen to be the Tiria-Novanda and the Tiria-Kitawa BITs, as well as the ICSID Convention, then conditions for access must be satisfied in both of these instruments, for the simple reason that a member's consent, expressed by way of paragraph 1 and paragraph 3 of Article 9 of the BITs, cannot be said to be impervious towards that member's actions and that member's actions taken in respect of the Convention. The mere fact, respected tribunal, that one entity had expressed their, quote, unconditional consent, end quote, in the BIT is not the end of enquiry, for the simple reason that a BIT or any bilateral investment agreement in general cannot alter the scope of rights and obligations arising out of the ICSID Convention. A BIT providing for access to ICSID jurisdiction takes its relevance from Article 25, read with Article 71 and 72 of the Convention with respect to denunciation. Therefore, we plead that the critical and decisive date for measuring or gauging the effect of denunciation on consent is the date of receipt of notice.
But isn't that a rather technical reading of this which gives you an advantage? If you look at 71, it says it takes effect 6 months after receipt of such notice.
Yes.
And the RFA was sent with about 5.5 months, so before before it actually took effect.
Yes.
Correct. So they would be within time, wouldn't they?
Respected arbitrator, if
Substantively.
they would be well within their rights to a perfected consent if that request for arbitration was filed before 5th January 2018. Now, if we look into the express interpretation, notwithstanding Schroer and notwithstanding the decision in Fabianca, it can be seen that Article 72 only preserves perfected consent provided that it was perfected before the date of receipt of notice. That is explicitly stated within the wording of 72. Now, 71 cannot be read in and of itself to justify the 6-month period, for the simple reason that, and quoting Schruer, Article 71 tends to treat parties as parties to the convention. However, Article 72, relevant in our regard, tends to treat parties as parties to the dispute, and that, respected arbitrator, would only be possible if their request for arbitration, which signifies their consent, was submitted and filed before the date of receipt of notice.
But that's not what the convention itself says, right? These are words that you're reading into it.
As a matter of fact, this is what the convention under Article 72 explicitly states. If for the sake of clarification, the council shall read out the express provisions of Article 72.
Sure.
Notice by a contracting state pursuant to Article 70 or 71 shall not affect the rights or obligations under this convention of that state or of any of its constituent subdivisions or agencies or of any national of that state arising out of consent to the jurisdiction of the center given by one of them before such notice was received by the depository. In this present case, that expression of consent by way of the request for arbitration was only given several months after the date of receipt of notice, thereby currently violating the express conditions under 72.
Okay.
Proceeding to the final argument.
Counsel, as far as 72 is concerned,
Yes.
it refers to notice by a contracting state pursuant to 70 or 71.
Yes.
So that contracting state is you, right?
Yes.
Now, shall not affect the rights or obligations under this convention of that state or any of its constituent subdivisions or agencies or of any national of that state arising out of consent to the jurisdiction of the center given by one of them before such notice was received by the depository. So the notice being referred to in 72 refers to the notice given by a national of your state, not to the notice for arbitration given by the claimant.
Respected arbitrator, I sense some misunderstandings occurred in this regard. The notice referred to under Article 72 explicitly means a notice of denunciation by the contracting state.
Right, absolutely, exactly right. But in your argument, you are referring to that notice as the request for arbitration given by the claimants.
No, the request for arbitration given by the claimants is a separate document which can be seen at the very beginning of the structural matrix.
But then that 6-month period, your notice of denunciation has not taken effect at all. The way in which you are placing it is for 71 to be read subject to 72. Whereas actually it is quite likely to be read the other way around.
Respected arbitrator, in that scenario, looking from the express terms of 72 in regards to a notice under 71, we are not contending that a request for arbitration given by the claimants is an expression of consent. We are claiming that it cannot be perfected if it was given at any point of time after the date of receipt of notice. And this is not the council's opinion, and this is not merely Schruer's opinion. This is the express and literal terms of Article 72. See, is the respected arbitrator satisfied with that answer?
But I take your point.
Thank you. Seeing that my time has elapsed, the council requests permission of at least 1 or 2 minutes to make his final argument.
Go ahead.
I'm grateful. The final contention put forward by the counsel for the respondent is that, respectfully, this tribunal does not exercise jurisdiction in respect to a multi-party claim. If the respected arbitrators would please take their attention to paragraph 6 of the response to the request for arbitration, which may be found on page number 23 of the record, para 6, we state that the claimants cannot proceed on a multi-party basis before this tribunal since A, the respondents have not provided their explicit consent to multi-party arbitration, and secondly, that there does not exist enough legal and factual similarities in this case to justify hearing it on such a basis. We were relying on the dissenting opinion of arbitrator Abisab in Abaclac versus Argentina, read with the dissenting opinion of arbitrator Santiago Torres Bernardes in Ambient versus Argentina. It is true that the ICSID convention, as well as the ICSID rules, and in the present case, the BITs, are silent regarding the ambit of multi-party arbitration. However, this silence and this absence of written regulation cannot be construed as meaning an absence of rules. Silence, in this case, quoting arbitrator Abisab, implies ambiguity. This ambiguity is only satisfied with the expression of consent, implied or explicit, to a different form of procedure, that is multi-party arbitration. The two terms defined here are primary and secondary consent. Primary consent being merely consent to arbitrate, wherein, in the words of arbitrator Santiago Torres, secondary consent meaning consent to a different form of procedure, that is, the procedure of hearing several claims in one hearing. On our second ground, regarding the fact that there does not exist similar legal and factual commonalities between the parties, we would like to take this tribunal to the findings of the tribunal in Alemany versus Argentina, wherein a certain threshold for the same was discussed. In order for a multi-party claim to be continued to be heard by a tribunal, the interest represented on each side by the variety of claimants must be identical in all essential
I
respects.
think your time is up.
May I have 30 seconds to wrap up?
All right.
Thank you. In terms of this, we put forward that in the fact that the claimants, the three claimants, are of different nationalities, their investments were made at different points of time. The first being in January 2015 and the rest in June 2015. And the fact that their problems have not arisen out of the same ordinance. Friends Look issues arisen out of ordinance dated 28 February, while Speak Up and Whistler their disputes have arisen out of ordinances dated 1st March and 2nd March respectively. There exists no commonality either in nationality, either in the relationship between the claimants, nor in their time of making investments to justify hearing this case on a multi-party basis. With that, the council cedes this argument.
Thank you.
Thank you.
Am I audible?
Yes.
Madam President, members of the tribunal, a very good afternoon. My name is Shrija Sengupta, and to my left is my colleague, Mr. Divyansh Sharma, and together we represent the claimants in the case of Friends Look, Whistler, and Speak Up Media versus the Republic of Tyria. I will be utilizing 18 minutes to submit on issues A to C regarding provisional measures and jurisdictional questions, while my colleague will be utilizing 20 minutes to summarize issues D to E on the merits of the case. Members of the tribunal, this dispute revolves around three social media companies who had invested in the country of Tyria. While initially Tyria welcomed us with open arms by liberalizing their laws, however, the moment they sensed an impending dispute, they denounced the ICSID Convention and later sabotaged our investments by way of blocking our platforms. Members of the tribunal, they resulted in curbing the freedom of speech and expression of not only their own citizens, but are trying to do the same with us, the claimants, by asking for provisional measures before this tribunal merely to protect their international image and their economic interests. Members of the tribunal, in this regard, I will bring three submissions. The first, that the provisional measures requested for should not be granted. The second, that this tribunal should find that it does not have jurisdiction, that it indeed has jurisdiction despite Tyria's denunciation of the ICSID Convention. And finally, that this tribunal should find that it indeed has jurisdiction over this multi-party claim. Members of the tribunal, I would now like to proceed with my first argument, which is regarding provisional measures. Under this, I will establish that the requirements for granting provisional measures indeed has not been met. And under this, I will be establishing first that the rights susceptible of protection that the respondent claims are indeed not jeopardized by the claimant's actions, and second, that the tests of necessity and urgency have not been met in this present case. Members of the tribunal, proceeding with the rights, they have sought the protection of right to non-aggravation of dispute by mentioning the fact that indeed we have engaged in employing a PR firm and have engaged in certain publications. However, members of the tribunal, if we were to notice the media titles on page 3, none of them are attributable to the claimants. They are published by international media houses. The
Counsel,
claimant...
can I just establish one thing? You've said that you're going to show that no rights have been jeopardized, but that in and of itself recognizes that a right exists. So you accept that a right exists.
In the international sphere, the right indeed exists, but with respect to the claimants, we have not jeopardized their rights in this dispute. Members of the tribunal, as I was demonstrating, the publications are indeed not attributable to the claimants at all. The only publication we have engaged in is the request for arbitration, as that is the only information which is privy between us and the respondents. Any other information are mere speculations by the media houses about this international situation where Tyria has curbed the freedom of speech and expression. And members of the tribunal, coming to the right of non-aggravation itself, it is qualified as a right which allows a party to not take any action, which renders it difficult to to render an award by this tribunal. And this concerns the legal dispute between the two parties, members of the tribunal, and not the domestic situation in Tyria. Any of our publication does not relate to the ethnic violence in their country. We have merely, as investors, stated that we contest their positions and there has been an expropriation and violation of the FET standard. There is indeed no ethnically charged information that can by any way escalate the volatile situation in Tyria. Coming to the employment of the PR firm, members of the tribunal, that the respondents contend. Members of the tribunal, as three claimants bringing a claim before this tribunal, we have merely engaged in a PR firm to provide a consorted media image to the international sphere. And this indeed is well within our rights. And this has been also identified in numerous articles, one authored by the Secretary General of ICSID herself, Madam Meg Keenyar. As well as I would like to point to the fact, members of the tribunal, that this PR firm was employed for expediting the bilateral resolution of this dispute. And these are good faith actions on our part, members of the tribunal, as it is not prohibited to want to settle the dispute in an amicable way.
How
And
would
that,
the engagement of a PR firm, Madam Counsel, help in that process?
certainly, members of the tribunal, this PR firm that we have engaged in is merely for a consorted media image that we want to portray to the international sphere. And that in itself will determine any publication or any statement made by the claimants. It is not any individual statements that will be held, each personal claimant will be held accountable for. And therefore, there is indeed no distortion of facts by the claimants either in this present case. Members of the tribunal, the respondents refer to paragraph 5 on page 37 on a media title named Hypocritical State Finds Freedom of Expression Hypocritical. This indeed is not evidence of the leak of any case materials on our part, but is a general opinion upon the dispute, members of the tribunal, because this very state who had emerged out of a civil war and had promised the liberalization of its media laws is now turning back on its words and blocking websites, curbing the freedom of speech and expression of its people. Therefore, it is a mere comment on the dispute, as the respondents themselves have said, which is undoubtedly permissible within the ICSID framework, as was held in the case of Bywater Goff versus Tanzania. Members of the tribunal, I would also like to tie into this the Mr. Arbitrator's concern about transparency. All the actions taken by the claimants are merely in the interests of transparency as well, and we have not engaged in publication of any case material of the respondents, merely our own request for arbitration, and that too is permissible within the confines of the ICSID framework, as was noticed in Bywater Goff, paragraph 156.
But I think the argument that's being run is not so much that you've disclosed material, but you've disclosed material selectively to suit your purposes, and that can't be transparency, can it?
Mr. Arbitrator, I understand your concern. However, this is indeed not the case. As I have demonstrated, their only contention is with respect to the media title in paragraph 5, which states hypocritical state finds freedom of speech and expression hypocritical on page 37, Mr. Arbitrator. And this is a general opinion about the case, and there have been publications along this line by other international media as well, such as Filtering Freedom Down, How to Do It in 3 Steps, and the like. It is merely a question on the government's stance and not any distortion of material, members of the tribunal. It is well within our right to freedom of speech and expression, and in the interest of transparency as well, to merely contest their case in this present matter. Members of the tribunal, now I would like to come to the aspect of necessity and urgency. As I have already, the requirement of necessity indeed is linked to an irreparable harm which is caused in the absence of provisional measures. And members of the tribunal, the respondent has not indeed shown any irreparable harm. The harm that they claim is the civil unrest and the loss of lives, which is indeed not related to any of the publications that the claimants have undertaken. We are not responsible for the ethnic violence in their country, members of the tribunal. We are mere intermediaries in this case, and dispelling any information about our case to the public is merely in furtherance of our freedom of speech and expression. Coming to the aspect of urgency, members of the tribunal, the respondent themselves, in the first hearing of this tribunal, in the presence of this tribunal, as given in Procedural Order 1, has accepted that these proceedings, the request for provisional, the decision on provisional measures, the decision on jurisdiction and liability will be heard at the same instance by this tribunal. Therefore, we do not understand where the urgency in their case lies, as they said that urgency requires that it cannot wait until a final decision on merits. However, all of the hearings are going to be done by the tribunal in the very same time. Therefore, there is indeed no arising of urgency in that instant case as well.
You see, if you look at the provisional measures sought, they're in essence asking that you do not further aggravate the dispute and jeopardize the integrity of the proceedings. Isn't that a fairly reasonable request?
I understand, members of the tribunal. However, we have indeed not done anything to aggravate the dispute, and our publication is merely of a request for arbitration, which indeed was also done in the case of Churchill Mining versus Indonesia, and the tribunal in that instance had held that merely stating that we contest the claim of another party does not rise to the threshold of aggravation of the dispute. Moreover, any employment of PR firm or any steps taken by us for expediting a bilateral resolution cannot be seen in bad faith, members of the tribunal. It is indeed well within our rights to want to settle this dispute. Members of the tribunal, now having concluded my first submission, I would like to move on to my second submission regarding the denunciation of the ICSID Convention. Consent indeed forms the cornerstone of any arbitration proceeding, and Article 25 of the ICSID Convention embodies the same. However, the same convention, through Articles 71 and 72, provides a mechanism to opt out of the membership of the ICSID by way of denunciation. If I were to bring members of the tribunal's attention to Articles 71 and 72, Article 71 states the general right of a party, contracting party, to denounce the ICSID Convention by a notice to the depository, and this will take effect after 6 months of this notice. And Article 72 protects any consent mutual that is provided before the notice of denunciation. Members of the tribunal, if we were to look at these two articles cumulatively, as the respondent has correctly pointed out, we were to notice that Article 71 indeed protects the consent that can be given by an investor within the 6-month period. The consent by the respondent had been given at an earlier stage by virtue of their unconditional consent in Article 9, Clause 3 and of the BIT that is signed between us. Members of the tribunal, we accept that it is a standing offer of their consent, and we as the investors have accepted that by virtue of bringing a request for arbitration on 29th June 2018. The 6-month period since the denunciation was on 5th January would end on 5th July 2018, and therefore we fairly fall within the 6-month period. Council would like to draw to your attention the case mentioned by the respondents of Fabrica. However, reliance cannot be placed on this case, members of the tribunal, as in that case, a cause of action had arisen in 2010, and only in 2012 had Venezuela denounced the ICSID Convention. In our instant case, if I were to draw your attention to the facts, on 5th January, the convention was denounced, and on 12th January, a notice for the claimants to prepare an algorithm was passed for the first time. Members of the tribunal, there was no semblance of a dispute before the denunciation. How are we to preemptively give our consent to any dispute resolution process before that? Therefore, indeed, this 6-month period, it is our contention, is in light of this object and purpose of the treaty to allow for the settlement of disputes. And this indeed promotes an allowance of the settlement of disputes by allowing a 6-month buffer period in order for any investor to bring their claim. And this indeed has been supported by previous decisions of the in the ICSID framework, such as Venoclim versus Venezuela and Blue Bank International versus Venezuela. Members of the tribunal, I would now like to move on, if there are no questions, to the third submission before this tribunal regarding the multi-party nature of claims. Multi-party arbitration in the ICSID framework is indeed not unheard of. In fact, 40% of the cases brought before the ICSID has indeed involved multiple claimants, and this, members of the tribunal, is also in furtherance of the broader policy objective of saving the time of the tribunal, cost effectivity, management of resources, and most importantly, preventing inconsistent awards.
Have there been other cases brought under two different treaties?
Certainly, Mr. Arbitrator, a case in point being under the ICSID framework, Fluhazen versus Venezuela, wherein there were two different investors under the Switzerland, Venezuela and the Chile, Venezuela BIT, and they had both brought a claim against Venezuela for expropriation. And this multi-party claim was allowed because, members of the tribunal, in that case, the examination by the tribunal was on the similarity of the BITs. The standard examination that the tribunal took was whether the substantive protection of the two BITs that they provide to the foreign investors are the same, and that these BITs are not incompatible. Those BITs indeed had different wordings. In our case, the case is even stronger because our BITs, in the present case, members of the tribunal, are verbatim the same for the substantive provisions, and indeed they provide a similar protection, therefore, to the foreign investors. Therefore, this claim can indeed be brought under two different BITs. Also, with respect to the factual similarity, members of the tribunal, indeed these claimants have all invested in the same industry, in the same year, have been subject to the same laws by the respondent and the act of blockage by the respondent, and have brought the same reliefs. In these circumstances, not only in the interests of the claimant, but also to save time and cost for the respondent, and in the interest of an efficient arbitration process, we have clubbed these claims together.
But you accept, as the claimant suggests, as the respondent suggests, that there is nothing in the convention itself that suggests that multi-party claims can be accepted, nor is there a provision for consolidation.
Certainly, Mr. Arbitrator. Indeed, it was this no express provision for multi-party disputes that were examined by cases like Abaclat and Ambiente, the dissenting opinion of which the learned respondent counsel cites. In these cases of Abaclat and Ambiente, they determined that the silence in the ICSID convention is not meant to have a formalistic interpretation of not allowing for multi-party claims. Indeed, the TRAVO of the ICSID convention also had envisaged multi-party claims. They were not beyond the purview of the ICSID framework. In fact, coming to the point of secondary consent that the respondent raises specifically to these particular proceedings, as they claim that these are new set of proceedings, our contention is that in the case of Ambiente as well, it had been recognized that there is no specific consent that needs to be given to multi-party proceedings. This respondent's consent is encompassed by its consent given by virtue of its BIT in Article 9, wherein they have given their unconditional consent to the ICSID framework. And the ICSID framework, multi-party claims are not beyond the purview of the ICSID framework, members of the tribunal.
They're not provided for either. They're not provided within the framework.
Certainly, Madam Arbitrator, and therefore in the cases of Abaclat and Ambiente, and it was relied upon the fact that this silence must indeed indicate to the fact, in light of the TRAVO, in light of the ICSID practice, and in light of the broader policy objectives as well, to indeed allow for multi-party proceedings wherein it is convenient and there is a factual and legal similarity, as indeed has been noticed in our case. Members of the tribunal, if there are no further questions, I would like to conclude my submissions. Thank you for your time.
Yes.
No, it will be
Rebuttals.
Council requests permission to proceed with the rebuttals.
Yes.
Thank you. While according all due respect to the submissions made by my learned colleague, the counsel for the respondent presents the following rebuttals. Firstly, it would seem, deliberately or otherwise, the counsel for the claimant has deliberately misinterpreted the decisions in both Bywater Gulf versus Tanzania as well as Flugaffin versus Venezuela. Addressing Bywater Gulf versus Tanzania, in that case, in using it as a justification for their media campaign, the tribunal herein stated that parties may only engage in a general discussion about the case in public merely for the avoidance of public doubt. In this case, as well as referred disputes such as United Utilities Stalin versus Estonia, selectively using case material, as my learned colleague pointed out by their publication of the request for arbitration, is merely an attempt at distorting the facts in favor of one party while not providing recourse to the other. Now, in coming to the dissemination of Flugaffin versus Venezuela, I do believe my learned colleague used it to justify the aspect of a multi-party dispute arising out of two separate BITs. However, in the case of Flugaffin versus Venezuela, the tribunal only acceded to this fact because the matters arose out of the same dispute. In the present case, the dispute here for all the three claimants has arisen out of three separate ordinances dated 20th February, 1st March, and 2nd March respectively, which may be found as claimants exhibits 4 on page numbers 11 through 12 of the record.
Your time is up. Your time is up. We give time for rejoin.
There's a surrebuttal.
There is, sorry?
A surrebuttal.
Yeah.
Good afternoon once again, members of the tribunal. I will be presenting three short surrebuttals. The first being that in Bywater Gulf versus Tanzania, paragraph 156, it is expressly stated that publication of our own pleadings or memorials indeed cannot in any way distort a context because it is merely our own contentions. It is not a one-sided story, it is our story, members of the tribunal. Coming to the general discussion of the dispute, we believe the respondent has also already accepted that a general discussion of the dispute is indeed allowed, and any opinion on the state's action is indeed allowed for as well. Members of the tribunal, coming to the case of Fluhazen and the multi-party dispute, the three ordinances that were passed effectively had the same effect of blocking our three websites, and it arose out of the singular law that provided the president with extraordinary powers to do the same, members of the tribunal. Therefore, there is an artificial distinction only on the face of it. If I may just conclude in one line. Therefore, indeed, there is factual and legal similarity to bring these claims together. Thank you.
Is it the claimant next?
Good evening, Madam President and members of the tribunal. As previously introduced, my name is Divyan Sharma, and over the course of next 20 minutes, I will be addressing the claim and submissions on merits. In particular, before this tribunal, I will be making three submissions. The first, that the complete shutdown of the operations of our platforms in the Republic of Tyria amounted to a violation of Article 6, that is the expropriation standard, under both Tyria Novanda and Tyria Ketoa BITs. I will be secondly submitting that such a complete shutdown violated the fair and equitable standard which can be found in Article 3.1 of these BITs. And thirdly, in the event liability is to be found upon the state of Tyria, we submit that a discounted cash flow method is the only appropriate method that should be deployed by this tribunal for the valuation of the enterprises. Now moving on to address my first submission, members of the tribunal, if I may be allowed to draw your attention towards page 56 of the record of disputes. If the tribunal is with me. On page 56, Article 6, of which we claim violation of, can be seen. Article 6 states, neither contracting party shall take any measures depriving, directly or indirectly, the nationals of other contracting party. Members of the tribunal, we submit that the scope of protection under Article 6 does not merely include formal takings of the property or directly expropriating of the properties, but also includes an indirect expropriation, which basically translates to the situation where the measures undertaken by the state deprives the investors of their investments, and their investments lay effectively neutralized as a consequence of the actions, as if these rights never existed in the first place.
Mr. Counsel, don't you think that there is a justification by the state to have taken these steps, particularly in view of the ethnic wars which were taking place in this country? What is your response to that?
Indeed, Madam President, that will be my next contention. Firstly, after establishing that there in fact was substantial deprivation in the present case, given that all our revenues were only generated in the condition on the condition that our platforms were functional, and therefore we submit that there was substantial deprivation rising to the threshold of expropriation. Now, moving on to Madam President's concern on the legality of this expropriation. We submit that the legality of this expropriation is to be judged in the light of Article 6, given that the host state has signed Article 6 as its international obligations, and Article 6 clearly spells out certain requirements for undertaking measures which are expropriatory in nature and can be qualified as legal under these BITs. Now, while public interest is in fact a requirement under Article 6, what is also a requirement is Clause C, that is, these measures undertaken by the state are to be accompanied by a provision for payment of just compensation. In the present case, we submit that even if the respondent state claims that there was a public order crisis, and we agree that and we regret that it was in fact a bad situation in the Republic of Tyria, however, we submit that given that it is an investor state dispute, our rights under these BITs have in fact been violated because a provision for compensation was not made.
I have a question on that's slightly more. It's a simpler question, which is around what exactly has been expropriated. As a matter of assets, as I understand it, none of your physical assets have been taken, or you've not been deprived of access to those assets. So when I think of expropriation, I think of a state basically taking over assets of that nature. What do you say in response to that? What is it that's been expropriated?
Mr. Arbitrator points to an important concern and takes me back to my previous submission. Members of the tribunal, we submit that the discourse on expropriation has changed and the understanding of expropriation has evolved in exit tribunals. We submit that it is not merely required that there may be formal takings of the property. However, what is in fact required is that that effectively the investments of the investors are rendered effectively neutralized. That is, the investor can no more use those properties or are deprived of the reasonably to be expected economic benefit of the property, as was held by the tribunal in Metalclad versus Mexico and TechMed versus Mexico. Members of the tribunal, we submit that in the present case, our assets were our right to generate revenue out of, as they are also protected under the definition of investment in the present BIT. If I were to draw your attention to Article 1. Article 1 includes not only movable and immovable property in Clause 1, but also in Clause 4 includes rights in the field of intellectual property, technical processes, and know-how. Therefore, we submit that these rights, these assets which are protected as investment in the present case, lay effectively neutralized in the Republic of Tyria post a complete shutdown of our platforms in the state.
But there's no suggestion that your IP rights have been taken away, right?
Mr. Arbitrator, we in fact have a trademark on the domain name, and therefore we in fact exercise rights against the trademarks of the names of Friendslook, Whistler, and Speak Up, which are the claimants in the present case. And therefore we submit that all these assets cumulatively are protected under the BIT and qualify as investment. And we have been effectively neutralized of these investments in the present case. Now, coming back to my submission on the violation of Article 6, we agree that there may be a situation, as Madam President also points out, that there is in fact a public interest objective, and we do not contest this public interest objective. However, as has already been shown before this tribunal, that for such expropriatory measures to amount to legal expropriation under the BIT Article 6, they have to comply by the and included and accompanied by a payment of just compensation, which was not done in the present case. However, even if the respondents may like to claim the defense of police powers of the state, we submit that investment tribunals have repeatedly observed that the defense of police powers is also conditional on certain circumstances being met, and they have not been met in the present case. If I were to cite a few instances of these tribunals, such as Saluka versus Czech Republic and Philip Morris versus Uruguay, all these tribunals have repeatedly affirmed that for the exercise of police powers, so as for an expropriation to be made non-compensable under international customary law, there have to be certain requirements that have to be met by the host state in undertaking these measures. Now, these requirements are, first, that these measures must be proportionate in nature. Second, that there must be no discriminatory nature of these measures. And thirdly, that they must follow a due process requirement. And we submit that on all these three grounds, which are also grounds under the BIT itself, the actions of the host state have failed to fulfill these grounds.
Can you substantiate it?
Indeed. Madam President, firstly, on the concern of proportionality, we submit that the requirement of proportionality or the test of proportionality is that the means deployed is proportionate to the legitimate objective that the state is trying to achieve. However, there is also a requirement that there should be no individual and excessive burden on a particular entity as a consequence of state undertaking certain measures. And there is also a requirement under the proportionality itself, as have been noted by multiple tribunals, including the TechMed versus Mexico, that the measures that are adopted by the host state must be the least restrictive measures in order to harm the rights of the investor. That is, out of the available alternatives which are available to the host state to achieve the same legitimate objective, the least restrictive measure out of them should be adopted by the state. And in the present case, we submit that there are in fact lesser restrictive measures that the state could have adopted.
For instance?
For instance, Madam President, we submit that there were in fact certain particular hashtags which were being used by radicalists to propagate the posts. Given that the Republic of Tyria claims to be a democracy itself, we submit that there could have been a direction to the social networking platforms as opposed to a blanket blockage of the entire communication that happens on this platform to remove those fake accounts and to remove those hashtags on these platforms. However, in any case, we also submit that even if there were to be a blockage for achievement of the legitimate objective, this blockage could have been temporary in nature, given that the host state claims that the crisis is impending at that point in time when they took the impugned measures. However, we submit that...
Sorry, just on that, it says pending further notice, right? They didn't make this a permanent block, did they?
Indeed, Mr. Arbitrator, I understand your concern. While it was pending further notice, however, the procedural order 2 clearly states that post-blockage, our representatives in fact tried to approach the Tyrian authorities in order to get certain assurances as to whether our operations would ever continue in the Republic of Tyria. However, such assurances were never given and all these meetings were in vain. Members of the tribunal, we implore you to consider the situation of an investor who has made a multi-million-dollar investment in the Republic of Tyria, but the state has failed to consider the interest of this investor and the financial purpose with which this investor invested in the first place.
How
And
have you computed your investment? How have you computed, on what basis?
Madam,
What is the basis of your computation of the investment you made?
Madam President, while that would be my third submission, however, I would briefly state that the major test for computation of our investments in the present case, the major revenue generating way of our enterprise is the online advertisements and the sale of pro features of these platforms, which can only happen in the event that our functionalities stay intact, and which was not done in the present case. Now, moving on to address Mr. Arbitrator's concern that the ban was temporary in nature, given that it was until further notice. As I have already stated before this tribunal, that the ban was effectively permanent. Now, it has been 528 days and our platforms still remain blocked in the Republic of Tyria as we speak today. We submit that this ban was effectively permanent and there was no realistic expectation for us to continue in the Republic of Tyria. And therefore, in the light of that, we submit that these measures were in fact disproportionate. Now, moving on
Mr.
to...
Counsel, I had one question. Initially, when the law came in, you were actually cooperating to create the algorithm. Is it then justifiable for you to say that it is an expropriation of the nature that you are pointing out? Because the initial effort, even on the part of the claimants, was actually to comply.
In fact, Mr. Arbitrator, which is why we submit that we in fact in good faith have always tried to comply with the law. The initial law was passed on the 12th of January 2018, where the regulations were for the first time brought. Thereby, a 60-day deadline was given to us to comply with an algorithmic development which is automatically supposed to block all the hate speech and speech that is likely to incite discrimination in the Republic of Tyria. However, 1 month post this period of 12th of January, on the 11th of February, even after continued assurances on the part of the state that sufficient time would be given to us, they slashed the time period by more than 25% and effectively reduced the last 15 days of the 60 days and made the time period 45 days, effectively cutting down time for us to plan our investments in order to comply. And that would be further addressed in my second prong of legitimate expectations, where we submit that the consistency on the part of the host state in the present case was not met, and the requirements of not confusing the investor so as to continuously changing the compliance requirements in the present case, as well as laid down by the tribunal in Saluka versus Czech Republic, in fact was not met. Now, moving on to address this tribunal on the discriminatory nature of these regulations, given that their regulations cannot have the defense of police powers unless they are non-discriminatory in nature, we submit that the test of discrimination requires an analysis of whether the entities are placed in like circumstances. In the present case, we would like to draw your attention towards paragraph 13 on page 50 of the uncontested facts. Fourth last line from the bottom, members of the tribunal.
Yes, proceed.
In this fourth last line, it is stated that Frenzluck, Whistler, and Speak Up, who are the claimants in the present case, were not the only platforms used by radicalists. For instance, Wink, a local messaging platform, was also being used in the Republic of Tyria. There is another platform which has mentioned later, platform called Truth Seeker, which the respondent state itself had developed in the year 2014 and is a similar social network. Now, the Article 51 bis requirement, which was passed on the 12th of January 2018, required of every social media network to have an algorithm in place according to their scale of operations. And this algorithm, according to the audience you cater to, should be effective and efficient in nature in order to block the hate content on your platform. However, the respondent in the present case justifies the non-blockage of Wink by saying that there were spam messages on their platform and therefore this algorithm was inefficient. We submit that Wink should in fact also be penalized in the way we were penalized, and therefore the standard of non-discrimination was not met. Further, the respondent state never clarified or gave a reasonable explanation to us why the platform of Truth Seeker was not blocked in the first place. Madam President and members of, do I sense a concern?
Yes, does anti-discrimination require people who are placed at completely different levels of operation to be treated similarly?
You raise an important concern, Mr. Arbitrator. We submit that in the present case, entities in fact had different scale of operations. However, there was a discriminatory treatment in terms of the implementation of Article 51 bis itself. Even independently of Article 51 bis, we submit that the threats to public order existed from all of these platforms, given that all of these platforms were being used for spreading of hate content and proliferation of false information. If I were to use a mathematical...
Would that be true of Truth Speaker also?
Indeed.
Would it be true of Truth Seeker also?
Indeed, Madam President. It is in fact stated in paragraph 13 itself that Truth Seeker was also being used for the dissemination of the same content. Now, if I were to address your concern on the number of people using these platforms by the way of a mathematical instance, given that the respondent's platform, the Truth Seeker, was also being used by 1/5 of the users of the claimant's platforms. Therefore, if our platforms were being used by 100 million people, the threat from the usage of 20 million people itself can create a ripple effect, as they claim there is in fact a severe public order threat in the Republic of Tyria. Therefore, Madam President and members of the tribunal, we implore you to consider our submission that there was in fact a failure on the part of the host state to treat us in a non-discriminatory manner, and therefore they cannot exercise their defense of police powers that they in fact have legitimate objective so as to not compensate under Article 6 for the same effect. Now, moving on to address this tribunal on the third prong of due process requirement. We submit that the requirement of due process, as has been observed before in the tribunal of ADC versus Hungary, require not just an actual due process, but the requirement of a substantive due process also exists in international law. We submit that the host state failed to give us a reasonably advanced notice and nearly tendered us a notice 2 weeks before they would continue with the blockage of our platforms, therefore making it impossible for us to continue with the development of this algorithm. And we in fact still tried to race against these unrealistic deadlines. However, it was an obvious scenario that we failed. Having addressed this tribunal on how the respondent's action failed to abide by the defense of police powers, which they cannot exercise therefore in the present case, and owe us compensation for the same, we now move on to address shortly the violation of the treatment of fair and equitable standard under Article 3.1 of the BITs. Madam President and members of the tribunal, as has already been submitted, that there was in fact an unreasonable treatment given the requirement of reasonability also includes a test of proportionality. Therefore, we submit that there was an unreasonable treatment that was meted out to us, and that treatment in fact was discriminatory. And both of these are requirements under Article 3.1 of the BITs itself, which can be found on page 55. We further also submit that there were violation of legitimate expectations on the part of the investor, given that, as has also been noted by the tribunal in the case of TechMed versus Mexico, that there are certain basic expectations that the investor has in mind at the time of investment, and when the actions of a host state violates these expectations, it amounts to a violation of the fair and equitable standard under investment law.
But there is always a caveat to it, that if there is an extraordinary situation which affects public interest, public order, then you can't expect that there has to be an inconsistent. It's not a situation which is normal. So you can't expect your investments to reap the same benefit during that period.
Indeed,
Would you agree with me or no?
Indeed, Madam President, we agree on the fact that there is in fact a defense of regulatory powers, and states by their very sovereign status inherent to them enjoy a certain power to legislate on the investments in their territories. However, we submit that the state cannot escape the requirement of compensation under the BITs if it chooses to do so, given that it has not abided by the requirement of non-discrimination, due process, and proportionality in the given case. Now, given that I am running out of time, moving on to address this tribunal on the damages issue, which is the third issue, we submit that the discounted cash flow method is the appropriate method for value calculation of our enterprises in the present case. This method takes into account not only the physical assets or the investments or the costs we incurred on investments in the first place, but also if we can predict with reasonable certainty the profits that an enterprise would have generated at the time it was blocked. That is a criterion under the discounted cash flow analysis to be undertaken by this tribunal. We submit that the World Bank guidelines on the treatment of foreign direct investment itself submit in Chapter 4, Clause 6.1, that for going concern enterprises, that is the enterprises that have been in function for a sufficient period of time and have been generating, if I may just be allowed to conclude my submission on this, and have been generating a sufficient revenue over the number of years they have been functioning, then a discounted cash flow analysis should only be employed. Therefore, in the present case, we submit that given that we have been in operation for around 3 years in the Republic of Tyria and have been generating multi-million dollars each passing year, we in fact qualify as a going concern, and therefore according to the World Bank guidelines and the practice of investment tribunals, a discounted cash flow analysis is the only method of value calculation that should be deployed by this tribunal in the present case.
Thank you.
Thank you for your time.
May I start?
Yes, please.
Very good evening, Madam President and respected members of the tribunal. My name is Abhishek Mishra, and over the course of the next 20 minutes, I shall be addressing the tribunal on issues of merits and damages. With regard to the issues on merits, we have two main submissions. Firstly, that the respondents, by blocking the claimants' websites, have not indirectly expropriated their investments. In arguendo, we shall submit that if this tribunal were to find that we have indeed indirectly expropriated their investments, the state is precluded from responsibility as a result of a legitimate exercise of their police powers. If the tribunal has no preliminary questions, if I may proceed to my first argument. I'm thankful. Our first submission is that in the instant case, yes, there has been deprivation. However, the deprivation that they claim is in respect of assets which do not amount to an investment. If I may kindly guide the tribunal to page number 56 of the record, Article 6. Now, my learned colleague, opposing counsel, read the article but conveniently missed out the most important part of the article. Now, the article goes on to state that no contracting party, in this case the respondent, shall deprive directly or indirectly the national of an other contracting party, in this case the claimants, of their investment. The operative term here is investment. For the sake of clarity, I now submit it is not our position that the claimants are not foreign investors in our state. What we are stating is that the deprivation that they have claimed is pertaining to assets that in and of themselves do not amount to an investment. And Article 6 only protects investments. Now, for an asset to raise itself to the definitional criterion of an investment, it has to fulfill two standards. Number one, it must be an asset within the meaning of Article 1 of the BIT, which is a definitional clause. And number two, since we are presently before the ICSID tribunal, it must fulfill the definitional criterion and tests laid down by this tribunal pursuant to Salini test and Article 25. I sent some.
No, I'm listening to you. I do have a question, but I'd like
Certainly. Let's analyze what the deprivation is regarding. There are two types of contracts. Firstly, advertising contracts that third parties have entered into with the claimants to advertise on their websites. Number two, the money the claimants charge the users in the territory of Tyria to access certain features which are otherwise blocked. Now, these assets in and of themselves are not investments. We acknowledge that there have been certain cases of the ICSID wherein essentially the tribunal has split the entire investment into discrete rights, and there have been findings of indirect expropriation, such as the N-Cana versus Ecuador case. However, that case is different from our case, as in that case, a VAT refund was pleaded by the claimants to have been expropriated. Now, the tribunal in that case, yes, did split up the whole enterprise into discrete investment rights. But before making a finding for indirect expropriation, they evaluated that VAT refund in light of the BIT and held that because those VAT refunds in and of themselves, basically the asset, is also an investment, hence they were entitled to damages.
Perhaps I can ask the question now. You recognize that they are investors,
Certainly,
and therefore, by definition, have made an investment in your state.
certainly.
If that particular investment required a business that would consist of the sort of revenue generating activities that you just described, wouldn't that be taken in totality as the investment that they're making in the country, as opposed to what I think you're saying, which is the assets themselves represent the investment, but not the revenue generating elements that those assets would be deployed in the context of that business. Is that your argument?
Certainly. However, to submit
Is
to
that your argument?
if you may clarify,
So basically, the distinction is between the assets themselves, the physical
which
assets,
amount to an
and
investment?
what you're going to use those assets
Certainly.
to, how you're going to use those assets to generate revenue. And you talked about advertising and so on. So that you're relying on that distinction to say that that second bit, advertising and the like, cannot be considered an investment. Is that your argument?
If I may answer in a twofold manner, yes, that is our primary argument. However, if this tribunal were to rule against that, we have an argument. We have two argumentos, in fact. If these assets, as per the tribunal, are indeed susceptible to expropriation, then we submit that the substantial deprivation test in the instant case has still not been met. Now, for there to be a finding of indirect expropriation, there must be not mere deprivation, but substantial deprivation. Substantial deprivation of what? The assets. Now, in the instant case, the core investment and ownership rights of the claimants, which is the physical infrastructure they possess in our territory, is still intact. And as per the standard laid down in the CME versus Czech Republic case, it was if I may rephrase, CMS versus Argentina case, where the investor remains in control of the day-to-day operations and management of its business, the threshold criterion for finding a substantial deprivation has not been met. If the tribunal were to find that this threshold has indeed been met, I come to my third argument with regard to merits. That even if there has been substantial deprivation, the state in the instant case is precluded from responsibility to pay compensation and consequently from a finding of indirect expropriation as a result of a valid exercise of its police powers. Now, the Saluka Tribunal from Paris 254 to 264 went into the contents of police powers, wherein it stated that if a state adopts a bona fide regulation applied in a non-discriminatory manner for the general welfare, it is precluded from a finding of indirect expropriation. Hence, if we satisfy before this tribunal that our measures were non-discriminatory, our measures were proportional, and since our learned opposing counsel have raised the point of legitimate expectations, if we were also to establish that our measures have not frustrated their legitimate expectations, then we would be protected under the police power standards. So if I may quickly establish these arguments. Firstly, with regard to non-discrimination.
Mr. Counsel, when you're addressing this argument, just kindly bear in mind that you're drawing a distinction between taking of the assets and preventing them from doing business pursuant to those assets. That distinction appears a little artificial. So when you're developing your argument, please try and address that issue as well. I won't ask you to address it right now, but when you're developing your argument in these three limbs, just try and persuade us with a little more clarity as to what this distinction is and why you think it is a distinction that we ought to make. Because it really ends up depriving someone of the fruits of their investment without taking their assets. It will be a very awkward sort of result.
Certainly, Mr. Arbiter, I believe there's been a slight misunderstanding. While that was my first argument, in arguendo when I argue, we submit that even if they were actually deprived, even if we concede the point that the mechanisms of exploiting the business are indeed a part of the overall investment and hence have been subject to substantial deprivation, the defense we are invoking herein is the police powers defense.
Yes, that's a separate point. That's the
Certainly
second
not.
point. That is your last assuming everything against yourself.
Certainly.
You're still saying that we are protected by the police powers.
Certainly, Mr. Arbitrator. So the point is, regardless of what the distinction being made, if at this point in time it is accepted that their contracts, advertising contracts and the subscription fees are indeed an integral part of the investment and have indeed been substantially deprived, even then, as per the police powers test, which we shall establish was legitimately exercised, we are precluded from responsibility. If that clarifies your concern, Mr. Arbitrator. Thank you. Moving on to my first contention that the measures were indeed non-discriminatory.
What would be your response to that? Because their submission has been that 2 of these sites you have not blocked off. What is your justification for that?
Certainly. Now, the test for determining whether there has been discrimination is, as per the Saluka Tribunal, that similar entities are treated differently without a reasonable justification. Now, at the outset, it must be stated very respectfully that the mandate of the present tribunal is not to challenge the legitimacy or the legality of the law, but to look at whether the law has been applied in a non-discriminatory manner, which is what we shall establish. For the sake of convenience, if I may direct the tribunal to page number 8 of the record, which essentially states Article 51 bis. Now, Article 51 bis, in and of itself, does not create any discrimination. It basically lays down a universal standard. Now, the standard therein is that all social media networks, which includes the domestic players, must develop an algorithm. The efficiency of the algorithm must be as per the scale of operations, which includes criterions such as the audience size and the amount of user data generated. And I shall prove that it was exactly this part of the law which was used as a rational justification to block the claimants' websites and not block the other 2 platforms. Now, firstly, I would state 2 pertinent facts and then get into the analysis. As per paragraph 10 of the uncontested facts, ever since the claimants' platforms have entered our domestic markets, they have been widely popular, widely successful, are widely pervasive, and have had an exponential increase in the number of users engaging with their platforms. As opposed, as given in paragraph 12, the local platforms, ever since they have entered the market, have had the reversal, have had the opposite effect, because there is a lack of interactivity and essentially the user base is shifting. Now, why this is important is because we must understand how a social media network works, how these platforms function. Essentially, when a user logs on to a social media platform, what he or she sees is controlled by the business algorithm of the social media platform. And what is that based on? It is based on something called the network effect. Essentially, the more the number of users on a particular platform, the more is the data that is generated. The more data that is generated, the better inputs there are to the business algorithm. The better inputs there are to a business algorithm, the more connected and augmented that a message can be sent, and wherein communities and microcosms of the society are formed. This is the distinction we rely upon, which I will submit factually as well, is essentially present in their platforms and missing in the other two platforms. Now, evidence of the uncontested facts shows us in paragraph 12 that the radicalists in the respondent state essentially exploited this network effect, which is inherently present in their platforms, wherein within a matter of minutes, they could broadcast their extremist and enticing views to millions of people, creating a ripple effect and leading to a law and order emergency situation. Now, the reason why Wink was not blocked is because essentially we must look at the mode of operation of Wink. Wink is a one-to-one private messaging app. Hence, the sender sends a message to a receiver. Now, we acknowledge that the receiver can share it further, but that would also be to another person. So, it inherently lacks the public post feature which is present in their platforms. Secondly, coming to Truth Seeker, it is stated in the uncontested facts, which is the other domestic platform, Truth Seeker has 1/5 the number of users as compared to the claimant's platforms, and its interactivity and user interactive with the platform has been in steady decline. Hence, we don't see that inherent network effect present there. Because, and I will sum up my discrimination argument with this, the aim of the respondents is not to silence all voices of dissent. Our aim is to protect law and order and also allow the permissible levels of freedom of speech and expression. Hence, we did not go for a blanket ban.
But the claimant suggests that 1/5 of a number that I think he threw out of 100 million is in the region of 20 million. And that could still create quite an effect, couldn't it, on the ground? Why did you not feel that that would be something you wanted to block?
I believe there's a certain factual inconsistency. The population of the entire country is 120 million people. The claimants platform, the factual matrix does not state exactly how many users the FriendsLook has. It says that out of whatever X number, FriendsLook has 1/5 of the X number. So it's not in comparison to the 100 million. The population of the entire country is essentially what I'm saying. And that's the basis of the rational justification, because this is what the law provides, and the law cannot be challenged.
Even if one says, okay, 100 million is not a correct number, it's still in the millions, I assume, and 1/5 of that would still be a significant number, would it not?
It may hypothetically be yes, or if I may give an alternative answer. We see as per the procedural order number 2 that the platform of Truth Seeker was indeed used by as a result of the public emergency crisis, was used by the respondent state to dispel fake rumors, and was since it's a state entity, was actually used to curb and solve the problem.
Right. So because it's a state entity, you didn't feel, and they were assisting you in curbing the problems, you felt that they could be treated differently.
Certainly not. Our first argument is that to begin with, they aren't in a similar circumstance. Then our second argument is of a rational justification. And our third argument was that we used the claimants platforms for addressing our law and order problem.
But Mr. Counsel, in a sense, your third argument cuts into the first. Because the third argument works only if it does have reach. If Truth Seeker doesn't have reach, then your third argument wouldn't arise. It's only because it does have reach that you were able to use it to curb what was happening in the ground. So to that extent, it meets a very difficult, it puts on a very difficult proposition for you to make good.
Certainly not, Mr. Arbitrator. So as per procedural order number 2, which are the clarifications, it is stated that after the claimants' platforms were blocked, intuitively, one would assume that since the users, a substantial user base has lost access to their platforms, they would migrate to the other two platforms. But the same has not happened despite their promotional marketing efforts.
No, the question is if you were able to use it to curb the activity that was happening. That could only happen if it had reach. If it didn't have significant reach, you wouldn't have been able to use it for that.
There was an attempt, Mr. Arbitrator, the argument is not essentially that it was per se, an attempt was made along with other attempts such as blocking their websites and other initiatives. This was just one of the initiatives which we used, still in light of the circumstances of the network effect and the other arguments presented, if I may move on. Our second argument is that the measures were indeed proportional. Now, before I address this point, if I may address certain factual inconsistencies and wrong facts stated by my opposing counsel. Now, opposing counsel said that the block is a permanent block because 528 days have elapsed since the block and the block has still not been uplifted. However, the claimants' websites were blocked on the 28th of February, 1st of March and 2nd of March, and they themselves pulled out of the country, pulled their investments out on, as per question number 12 of the provisional order number 2 in the month of April. So it was them pulling out which essentially they are using to characterize the ban as a permanent ban. However, that is not the case. It was indeed a temporary ban. Now, proportionality analysis states, as per the TechMed case, that there must be a nexus between the measure and the aim sought. Now, the aim sought is to address the public law and order situation. Now, two measures could have been taken as per Article 117A of the Tyrian Penal Code. We could have either blocked them temporarily or we could have blocked them permanently. And we resorted to a temporary block, which indeed was proportionate. Now, opposing counsel also stated that a lesser restrictive measure, which is also a part of the proportionality analysis, would have been to block, and I quote, the hashtags and the communities and to flag down that content and not the entire website. That is a clear and express mischaracterization and false statement of the facts. The uncontested facts on page 52, para 19, clearly state that their algorithm essentially failed. And before they could flag down and take down the radical posts, several new anonymous posts crept up. So that was a measure which would lead to no solution because their algorithm was inefficient. So before they could take down, if hypothetically we would have given them an order to take down the radical post, before they would take down one post, 100 new posts would crop up. Hence, that was not
15 days to perfect that, which you cut down. They had a total of 60 days in the initial law to perfect that algorithm. But when you on day 30 say that now you don't have the time, then how does the algorithm get perfect?
Certainly. So that brings me to my next and last argument on merits regarding legitimate expectations. And I shall quickly wrap this up so I have certain time left for the DCF method. Essentially, the root of that argument that the slashing of 60 days to 45 days was wrong arises from their argument that there was a legitimate expectation of consistency on part of the state. Herein we submit on three grounds that there was no such legitimate expectations. Now, for an investor's expectations to be protected, they must be legitimate and reasonable in light of the circumstances. Number one, the assurances in the instant case by Mr. Anderson, who was a representative of the Tyrian Parliament, were not specific. Specificity test, as held in the El Paso Tribunal, states that the assurances must be specific as to the addressee and, more importantly, specific as to the object and content of the assurance. Merely stating investment promotional policies by a country which has just transitioned into a democracy, saying that we invite the biggest players in the social media platform to come invest in our country is certainly not, if I may wrap up, certainly not specific to the addressee or to the object and purpose. Secondly, we submit in arguendo, even if the tribunal were to hold that the assurances were specific as per the Duke Energy case, even when forming their legitimate expectations, they must base their legitimate expectations on an objective evaluation of the circumstances, not a subjective evaluation of the circumstances. Herein we submit, as recent as 2012, our country was suffering from civil war. In 2013, for the first time in the history of the country, there was a transition from a military dictatorship to a democracy. They could not have possibly, and ethnic tensions still subsist as per para 1 of the uncontested facts. they could not have, under any circumstances, formed a legitimate expectation that the law would not be modified, especially in light of a tangible and actual public law and order circumstance. If I may be given 30 seconds to finish my contention on damages.
Yes.
Sir, thank you. We have two main submissions. Firstly, there is no factual or legal link of causation between the act of our state and the harm suffered. The Lauder versus Czech Republic Tribunal stated that in case of an intervening act of a third party, which in this case are the foreign markets they are planning to expand to, if that supersedes the initial conduct of the state, the link of causation is essentially broken, which has happened in the instant case. We merely blocked their websites as a result of the law and order situation.
Thank you.
Thank you.
Good evening again, members of the tribunal. I'll be making rebuttals, very short rebuttals. Firstly, on the point of assets susceptible to expropriation, we submit that the tribunal practice has been, for example, in the case of Pope and Talbot versus Canada, where the ability to sell and therefore the ability to use their investment in any constructive manner was being deprived. Therefore, they were held to be assets susceptible to expropriation. Secondly, on the point of substantial deprivation, the control that the respondents claim we have is in fact effectively neutralized, given that we are left with a company with assets but cannot exercise our rights to business. Thirdly, on the point of police powers, they heavily rely on the case of Saluka versus Czech Republic, where the tribunal itself found that given the test of discrimination was not met, the state itself violated the police powers and therefore could not exercise it in that case. And in the present case, we submit that on both these platforms of Wink and Truth Seeker, in fact, certain hate speech posts are being shared and therefore they are also a threat to public order. And given that our platforms are synonymous to the internet for the population of the Republic of Tyria, if I'm be allowed to conclude my sentence, our platforms are synonymous to the internet for the people in Republic of Tyria. Therefore, given that the respondents platform of Truth Seeker itself is being used by 1/5 the population, the ripple effect created can in fact harm the public order and therefore amounts to a threat.
Thank you.
If I may begin my third rebuttal. Yes. Even if you were to accept that the jurisprudence on the subject of indirect expropriation, asset deprivation has shifted, we justified the same with our police powers doctrine test. Secondly, we relied on Saluka versus Czech Republic for the ratio, not the actual, even though there is no principle of stare decisis, we acknowledge that, but because the tribunal stated the contents and the context of the police powers case. What was held in that tribunal is not an issue. And we proved before this tribunal that the three essential criterions therein have been met, and hence we see no merit to the argument of our opposing counsel.
Thank you. Thank you to all the counsel. You all have very well presented all your arguments, and now we will go in with the final score.
May I please request the teams to step down till the scores are being calculated? Thank you. A very good evening to the eminent panelists, distinguished guests, and dear participants. It has been an absolutely gripping final with both the teams presenting their arguments with verve and confidence. Thank you, arbitrators. There was much to learn for us. I would now request the panel to give their feedback on the event and say a few words. I would request Honorable Justice Prateek Jalan to give his feedback and address the gathering.
Good evening, everyone, and may I start by congratulating all of you on both sides, all the counsel who spoke today, on a very strong and creditable performance. The facts are complicated, and the law perhaps even more so. So for you to digest it and be able to distill it in a form that is that was articulate and very, very crystal clear was really quite creditable. So many congratulations to all of you. I think actually that today's speakers are perhaps not in the room at the moment, is it? Are they here?
Yes, sir, the
Oh, you're all
speakers
here.
are right
Okay,
here.
okay, okay. Great. So I was very impressed with how you all did. In terms of feedback, I think you're all doing far better than I would have imagined at this stage of your careers. So the only one or two small things that I would put to you. One is that when you hear a question, take a moment to reflect on what is being asked, rather than responding immediately and strongly. It's worth taking a second to think about what is it that is troubling this judge or this arbitrator before you actually respond to it. I think when you've been preparing a case for as long as you've all been preparing on this problem, what tends to happen is you think you know all the questions that will come. But actually it does sometimes happen in real life, as it does in moot courts, that unexpected questions come up. Someone is not seeing it quite from the perspective that you were trying to put across. And it's important for a good advocate to take that on board and be able to change gears to address that argument. So that's one feedback. The other one is be careful in how you characterize the arguments of your opposing counsel. It doesn't sound very pleasant to hear that someone has deliberately said something or intentionally done something. You can say that it's wrong, the way they've characterized it is erroneous, or doesn't take into account these facts, or doesn't, but to accuse counsel opposing you of deliberate or intentional mischaracterization or misstatement of facts is best avoided or done with great responsibility. So only when you think that it is the counsel's misrepresentation or deliberate intentional mischaracterization that you put it in those terms. There are a couple of thoughts I would leave you with to take forward in your mooting careers, as well as hopefully in your careers after mooting as well. And with those words, many, many congratulations again for all of you who participated in these programs, whether you made it to the finals or not. You can take it from a generation of lawyers who didn't have these opportunities, that it is very valuable and very you are very privileged to have these opportunities to hone your skills in advocacy at this stage of your lives. I hope you will find when you come to court that we are as patient as we were today. But with that little caveat, you will do very well, and many, many congratulations.
Thank you, Judge.
Thank you, Judge. And I don't have a lot to add. I certainly agree with all of those comments. Perhaps I'll start at the last bit of what Judge just said. In terms of the quality of advocacy and quality of presentation, I've come here now for a number of years. I wasn't able to make in the last 2 years, I think. And what amazes me is how year on year the quality just keeps getting better and better. And that's fantastic. And that's really what we want to see, right? Now, a number of you will go on to present in international fora. And what that then means is, in that context, you will hold your own. You will be able to represent both yourselves and the nation in that international fora, in those international fora. And I think that will present extremely well. And I'm really heartened to see that quality being represented in moots like this. The one sort of tip that I would give is this, in addition to what Judge has already mentioned, and that's really, this isn't an exam, right?
one shouldn't approach it in that way. So you're not there trying to tick off every single point that you've got in your notes. That doesn't achieve terribly much in this context. What you're trying to do is to show to the tribunal that you understand your points, you understand the questions that are being posed to you, and you're able to address those questions. If you're able to do that, it really doesn't matter if you can't cover every single point. And the tribunals that sort of perform the function that we're performing, we're aware of the fact that there are a whole range of arguments that one can go into, some going your way, some going the other way. And you won't necessarily have the luxury of time to go through every single point. And there's no expectation that you do. But what really distinguishes a good advocate from one who's less effective is the ability to listen and address the points that are raised, whether in the context of a litigation, an arbitration, or a moot court. I think that's the critical element. So if there's one bit of advice I'd give to whoever is going on to present in these scenarios, is that listen and address. And I think if you do that, you will do very, very well. But congratulations. I thought it was a fantastic performance by all the participants today.
Thank you, sir, for all your invaluable feedback and suggestions. This should stand the participants in good stead for future events, and especially when they take their first steps in the profession. Moving on to the results, I would request Mr. Nish Shetty to give away the Best Memorial Awards. This year, the Best Memorial for Claimant goes to National University of Judicial Sciences, West Bengal. I would request the team to come on stage to collect their certificates.
Congratulations.
The award for the Best Memorial Respondent goes to National Law University, Delhi. I would request the team to come on stage to collect their certificate. I would request Mr. Nish Shetty to also give away the prize for the Best Respondent Memorial. Is the team here? I believe the team is not here, sir. Congratulations to the winner, and thank you, sir. The next award is for overall Best Speaker. Based on the prelim round scores, the overall Best Speaker is Ayush Kashyap from Hidayatullah National Law University, Raipur. I believe he's not here right now. All right. The scores of the final rounds have been tabulated. I would request Honorable Justice Prateek Jalan to announce the results and hand over the certificates.
So the results have been tabulated, and the winners are the team from NUJS Kolkata, who spoke to us. So can I invite the runners up first?
Yes, sir. Yes, sir. Congratulations. A huge round of applause for the winners. I would first like to invite the runners-up, Rajiv Gandhi National University of Law, on stage to receive their certificates.
Many congratulations to all of you.
Team winners, may I now request you to please come on stage and receive your certificates. Congratulations.
Many congratulations. Well done. Many congratulations. Congratulations to all of you. Really well done. Sumit. Oh, she's not here. Okay, we'll take it to her. It's yours. And this one is here. So many, many congratulations to all of you. Really well done.
The award for the best speaker in final also goes to Shrija Sengupta from National University of Judicial Sciences. I request the judges to hand over the certificates. Congratulations. Good luck to the participants for the global rounds. I would request all the participants to come on stage for a group photograph. A huge round of applause for everyone who participated in this competition. I request all the participants to come on stage for a group photograph, please, with the judges. Thank you. Thank you, sir. All teams can please collect their participation certificates at the organizer's desk. Thank you, judges. I would request the judges and the participants to join us for snacks. Thank you.
What was the most daunting thing about it?
Congratulations to the winner and thank you, sir. The next award is for overall best speaker. Based on the prelim round scores, the overall best speaker is Ayush Kashyap from Hidayatullah National Law University, Raipur. I believe he's not here right now. All right. The scores of the final rounds have been tabulated. I would request Honorable Justice Prateek Jalan to announce the results and hand over the certificates.
So the results have been tabulated, and the winners are the team from NUJS Kolkata, who spoke to the winners are the team from RGNUL Patala. So can I invite the runners up first?
Yes, sir. Yes, sir. Congratulations. A huge round of applause for the winners. I would first like to invite the runners-up, Rajiv Gandhi National University of Law, on stage to receive their certificates. Team winners, may I now request you to please come on stage and receive your certificates. Congratulations.
Many congratulations. Well done. Many congratulations. Congratulations, all of you. Really well done. Sumit. Oh, she's not here. Okay, we'll take it to her. It's yours. And this one is yours. So many, many congratulations to all of you. Really well done.
The award for the best speaker in final also goes to Shrija Sengupta from National University of Judicial Sciences. I request the judges to hand over the certificates. Congratulations. Good luck to the participants for the global rounds. I would request all the participants to come on stage for a group photograph. A huge round of applause for everyone who participated in this competition. I request all the participants to come on stage for a group photograph, please, with the judges. Thank you. Thank you, sir.